I'll tick the button now. It's okay. Yeah, recording. So hopefully you should be able to see a little snapshot of me in the corner of your screen if you've got the facility to see the screen. And then you should also see on the other side, you should actually see the presentation for the screen. Does that equate with what you're seeing?
That's all there.
Hi there, it's Philip here. So, Chris has said yes, so that's good. Tom said yes. Good. Well, you're pleased to know in a minute I'll turn my screen on. We've still got a few people still arriving. We're up to, there's currently 76 people who are connected through. It's good. So in a couple of minutes, about a minute, I'll blank out my screen and we'll start through the presentation. Wow, we're now up to 78 people out of a possible 101, so we'll see people still connecting through. Right, Kevin's arrived. Yeah, can I just ask, we're going to do a Q&A session at the end. If everybody in the meantime could go on mute, otherwise what will happen is as I'm talking, your interference, well not interference, but you talking will interfere with the broadcast, and obviously that will upset the quality of everything for everyone else. Okay, well, I think we seem to have settled down on numbers. So, Ian's just arrived. So I'll blank out my screen and we'll make a start of the presentation. So for those who have just joined us, you are on live. So I just ask, can you mute just for now so you can hear me? And then at the end, we will do a live Q&A session for as long as it takes within reason. I'm obviously unmute to participate in that. But in the meantime, just write down questions, because what we tend to find with this, it's a complex subject, and people tend to raise questions, and then when we get to the next slide or a few slides on, they tend to then realise that actually we've addressed the question that raised earlier on. So I'm just switching. So my camera should be out, but you should now see the main screen. If somebody could just send me a text and say yes. Thank you, Tom. Thank you, Neil. Justin. That's fantastic. Matthew, Alex, yeah, got you. Hussein, Paul. Thank you. Right. Okay. So we'll make a start if we may. So this is covers it's an introduction to GDPR. I've tried to prepare this as much as I can, so it addresses you as practices, and I've actually been out and talked to some of your members. I've got another member this week to interview. So we've had our first lockup of the day. I'm sorry, we've had one minor thing, and we tested all this. For those who was earlier, you would know. Okay, so we're back there. So what is GDPR? So the General Data Protection Regulation is a new piece of legislation, and it overrides and it automatically comes into effect in UK law. This is one of the reasons people have got slightly concerned. So with the Data Protection Act, originally it required Parliament to effectively enact it through Parliament. With the General Data Protection Regulation, it's directly read into UK law. So that's the first thing. It's legally enforceable after May the 25th. So you have we've still plenty of time to prepare, but obviously we need to be on that route of preparation. And we're advised by the UK government that it will still apply in the UK post-Brexit. It builds on the Human Rights Act, which is Article 8, the right to privacy. And in effect, GDPR, as it suggests on the screen, replaces the Data Protection Act, but is more stringent. It says far more stringent there. That is true in certain areas, particularly in terms of fines. But if you're already registered, which I hope you are, and we'll talk about this in a few minutes, with the Information Commissioner's Office, then it should be, and you're actually applying the Data Protection Act already in your practice, which again you should be. GDPR should not be a big step up. So yes, you should be conscious of it, and yes, you should be preparing for it, but I don't want you panicking about it, but we do need to look at it systematically. So part of my remit is that I've been commissioned by the Institute of Osteopathy to actually prepare plans and documentations for you, and so you actually have some blueprints that you can roll out. UK evidence indicates, anecdotal evidence indicates that lots of businesses are not actually prepared for GDPR. So what is GDPR all about? Well, first of all, it seeks to protect individuals, natural living subjects. So your patients, your potential patients, who all have rights. The rights to the safeguarding of their personal data that you may be storing for them, the protection against the processing of personal data where they haven't authorised it. So you've got to bear in mind that GDPR is one size fits all. So you may well have read about issues with Facebook and people having data removed and by seemingly processed perhaps by advertisers or others, which they didn't consent to. Well, in essence, this is what GDPR is trying to prevent. The difficulty is that this one size fits all, that a small practice employing one person has to, in essence, follow through with a piece of legislation that's been written for multinationals. So the safeguarding of personal data, protection of it, restricted transfer of it within the EEA, so it's outside the EU, so into Switzerland, for example, and Liechtenstein. But what you must not do is transfer data outside Europe without safeguards being put in place. And you may well think, that's fine, how would that affect my practice? But of course, many of us use different devices and marketing systems, for example, MailChimp, that's registered in Atlanta, and you're actually transferring potentially your data of your patients to the server in Atlanta to go out on MailChimp if you use MailChimp or Constant Contact or any of the other things. So there's quite a bit of things that actually need thinking through. Now, it doesn't apply to things in the public domain. So if people are already on Facebook, and they choose to reveal the names of their children, I put my 2 children on there because they are on Facebook and they are linked on my Facebook page, then that's in the public domain. GDPR doesn't apply to that. It may apply to Facebook, but it doesn't apply to information that I choose to make public. So hopefully that makes some sense. Some examples here of personal data. So your patients' names, the home addresses of your patients. Here's an interesting one, the email addresses potentially of your patients. The IP address of your patient's computer, bank account details, credit card, driving license, passport numbers. So you may well have passport details of staff who are working in your practice because you want to be a good employer and demonstrate that you people have got the right to work here, and you're retaining passport numbers and passport details. Well, of course, that's personal data. Mobile numbers, genetic, biometric data, people meet a certain size or profile. In fact, anything that can identify a living person or living subject. So how does this protect you guys? Well, the first thing is, and you know this already, hopefully within your practices, you've got to ensure that patient data is protected at all times from prying eyes. If your computers are password protected, they should be password protected. Filing systems, I find this not with your members or with members, but I find this with other businesses where I can go visit, and one of the tests I actually do as part of their GDPR audit is to actually go check the personnel records and see whether they're locked. And what I tend to find is that the key for the filing cabinet is hidden in a drawer that everybody knows where it's hidden, but pretend that they don't know where it's hidden. Well, that's not good enough. And the GDPR, if you're locking files up, remove the keys from the premises. There's also a need, and I've seen some of these agreements already, but you need to make sure they're in place, that there's a confidentiality agreement that your staff sign and they understand the responsibilities in terms of data protection, but that also subcontractors sign. So if you've got self-employed osteopaths coming in to do some work in the practice, then you need to make sure that you have a consultancy agreement in place that upholds the rights of your data subjects, i.e. your patients. So in other words, people can't just get access. Equally, you may well have a website, you may have an external IT company, and you may even, if you're a big practice, have a payroll company that does the payroll requirements. Again, there's a duty here. There's two levels going on. There's the confidentiality agreement for the IT people, so they don't reveal the patient information. So your IT consultants could be in a position to do that, but equally, your payroll company could inadvertently send the wrong payslip to the wrong employee. And in such circumstances, again, there's been a breach of data. Admittedly, it's a minor one, but it's something really in terms of best practice you want to avoid again. So have in place confidentiality agreements. In terms of the templates that I'm preparing for you, there will be one in there that you will be able to customize to your practice. So these are some of the areas that it could affect your business. And I appreciate if you're a very small practice, the impact is going to be minimal, but in essence, your HR records, your payroll, bank account, credit card details concerning patients, CCTV cameras. So if you have CCTV cameras at the front of your building recording patients coming in and out, then you actually need to declare in your privacy or privacy notice that you run CCTV cameras, how people gain access to that footage and how long you store it. And in some cases, it may just be that you actually put on an email address and you say, email this company, they do our cameras, they are acting as our processor for managing the cameras. But you need to be aware of it. Again, accountants, if accountants are getting names of patients because they're doing audits for you, again, they should be signing a confidentiality agreement. So marketing data contains potentially patient information as well, although at a lower level, but nevertheless it is. Now, medical records under GDPR, and in fact, for that matter, under the Data Protection Act, are designated sensitive data under the Data Protection Act, and under GDPR, special categories of data, or in the special category of data, I should say, which comprises a number. And we'll look at this in a minute in a bit more detail. But in essence, anything that contains personal data that can identify an individual is a problem, and the real issue for you is special categories of personal data, i.e. medical information, which you need to demonstrate the highest levels of security. Okay, so one of the things we need to understand, and I know many of you just want a set of blueprints that you can roll out for your practice and hopefully GDPR will go away, but one of the things you need to be able to identify and understand is your relationship in the process. So where do you fit in? Well, this is where controllers, data controllers and data processors come in. I'm just going to spend just a couple of minutes just explaining this, because hopefully then down the line you'll be able to identify who's a controller and who's a processor. So a controller is you hold data about your patients and your practice. You may well choose to pass that data to a processor. So that could be another osteopath who's carrying out some work, who's self-employed. It could be a mailing company doing a mailing out for you, or it could be somebody doing your staff payroll. So you're the control of the data, but you're giving the data to someone else to process. Hopefully that's relatively straightforward. Now, in some cases, you may well do all the controlling and processing in-house. So in essence, your staff are all pay as you earn, you don't really outsource any marketing, and you do your own payroll, in which case you are just purely a controller of data. However, here's the thing you need to be aware of. When you choose to outsource activities, i.e. the processing to do payroll or whatever, these people are now acting under GDPR as an extension of your business, and both you as the controller of the data and the processor are now jointly and severably liable for any data breaches. So if your payroll company ran away with your staff payroll information or sent it to the wrong people and there was any issues arising from that, then you would be jointly and severably liable with them, which is so important, therefore, that you actually have a processing agreement in place. And if anybody thinks that sounds a bit extreme, think about Morrison's. Morrison's had a data breach, roughly, I think, 298,000 records. Somebody decided to publish all their employees' and ex-employees on the internet. The consequence of that is that the man who committed that breach has now gone to prison, but in fact each of the data subjects, i.e. the 298,000 people or thereabouts, who were outed on the internet as Morrison's employees with more information, are considering suing Morrison for £1,000 each. The Information Commissioner's Office hasn't yet made a ruling as to the fine that Morrison's may be liable to pay. So that is an extreme example, but it underlines the point I'm making. So, where do these regulations apply? So this is just something you need to be aware of. They apply across the EU. So if you were treating a French patient, which is possible maybe in some cases, they can actually raise a complaint against you by the equivalent of the Information Commissioner's Office in France, or indeed if they were in Germany, elsewhere. So this legislation applies right across the EU, and it allows people not just to raise it direct in the country where the treatment took place, but in another country where they may reside. So you could have somebody you've given treatment to who's come on holiday, you've given treatment to, things haven't gone too well, I think there's been a data breach, they can then complain through the Brussels authority or the equivalent in Germany. So this stuff applies right across. We hope and we envisage that these things will be pretty minor for businesses like yours and indeed my own, but it's just something you need to be aware of. Also, for GDPR to apply, money doesn't need to have changed hands. So a good example is mailing. You don't actually know the person you're mailing. You're working on legitimate interest. You're not taking any money off them, but you mail them and there's been a data breach, in which case GDPR would still apply. Hopefully none of you are actually monitoring data subjects within the EU, but again, it applies there as well. So what does GDPR give you as individuals? Because tuning into that will help you tune into some of the issues you need to address as a practice. Well, if there's somebody with a squeaky noise going on in the background, I'm not quite sure what it is, but if you could just blank out your microphone for now, I'd be awfully grateful. So, key highlights. So they right to be informed. So we have to tell people.
Okay, booked in for 1 o'clock for double.
Somebody's not muted. Can you mute, please? I can hear you. 1 o'clock. Right. The right to be informed. So how patients' data is processed. You have a duty to tell them how you will process their data. This would all be displayed on the privacy notice, and you'd be getting a privacy, or depending on what part of the world you're in, privacy notice. And just for the record, it's sometimes called privacy statement and privacy policy. It's all the same document, but you will have a template that you can use, and it will cover these things off for your patients. But basically, in talking in terms of patients' rights, they have the right to be informed how their patient data is processed, the right of access, so patients have the right of access. Now, talking to some osteopaths, I know you already allow that, but just be mindful that people can have access to their records, as you know. The right to rectification. You've got my address wrong. I disagree. I wasn't in pain when I came in. The right to erasure, which is, we'll talk about this in a bit more detail, but basically, please remove me from your practice records. Doesn't actually mean that. It means please stop contacting me, but you're entitled and you should. We would advise you strongly to keep the minimum amount of information you need, because what you don't want to do is inadvertently contact that patient again, having been told not to contact them. And the only way you can guarantee that is to keep a master record with a minimum amount of data saying don't contact. The right to restrict processing. I don't want you to share any of your data with any other practitioners. Now here's a bit of a problem for you. The right to data portability. So the best way of describing this, I use an opticians in Harrogate and I want to use an opticians in Milan or in Cambridge. I can say to Boots, my opticians, please transfer my data to my new opticians in Milan or wherever they are, and they're duty bound to do that. But they only have to transfer machine readable information, so if it's handwritten notes, they're not obliged to actually send the handwritten notes. The right to object. I don't want you to process my data and store it anymore. Well, yes, they can request that, but you're within your rights to tell them the consequences. We cannot continue treating you. And the rights in relationship to automated decision making. Hopefully none of your practice are making automated decision making on the back of back problems, but if you're in the information society world, chances are you may well be profiling in terms of advertising, or you may be acting like some of the banks and doing an automated profile and writing to tell you that your credit limit's been increased or unfortunately decreased. So, protecting patients and potential patients' rights. So these are the things that we need to address. So I'm commissioned to produce a set of documents. These are the documents which will be GDPR compliant, we'll be producing for you. So we will be producing a privacy notice, depending on how you pronounce that, in what part of the world you're in, so privacy or privacy notice, to give to existing and new patients. We have asked you to display that on your website and also on your practice wall. We would also ask you when patients come in to give a copy of that to existing patients. The GDPR self-audit checklist, the key things you need to do. Now this will cover the key things, but obviously we can't guarantee people could spend a week learning about GDPR and still not know everything. So the checklist will be the key things you need to look at, but we can't guarantee it'll cover absolutely everything. The inter-contact document, so where self-employed people are contracted within your practice, obviously a client consent form, compliant staff confidentiality agreements. Many of you have got these already under the Data Protection Act. The ones I've seen, they're pretty good already. Best practice concerning data security, that is one of the areas I think that you will need to work hard on to demonstrate, because one of the things GDPR requires you to do is to demonstrate compliance. It's data security by design and default. And the idea is that you get to think about how you protect data. So it's not just a set of rules and regulations, which was what the Data Protection Act was about. GDPR is more. I'm sorry, we do seem to have more people trying to join us, and we've now reached our limit, 101 of the 101 on the thing. So we've got GDPR compliant, so we also will be doing GDPR best practice data security, data subject access request forms, so you can't just give data out or information, there is a limit. In terms of procedures and policies that need to be followed through when people want access to data, you can't just give them there. And there's also a suppliers audit sheet, so if you're worried about any of your suppliers, we can give you an audit sheet and they can comply. Particularly useful with payroll companies who haven't really, in many cases, got to grips with GDPR. Appoint a data protection officer. For most of you, if you've got more than if you've got a substantial number of employees, i.e. more than 250, you probably need to look at more formal processes, but for the most practices you will need a data protection officer, but you will need somebody who potentially fulfills that role within the business, who's not actually involved in operational matters, i.e. marketing stuff. Call recording and CCTV surveillance. Again, this is covered. We need to make people aware that that stuff's been, if you're recording people, but you're actually doing that and how they actually get access to that. So what's the principles? The law talks about, or GDPR talks about fairly and lawfully. So if we simply what it means is we're clear enough from how we process the data. and you process things in a fair way and in a lawful way. A bit of legalistic speak here. So only collect data for specific, explicit and legitimate purposes. So in other words, you've got to be clear what you're collecting it for. So you're collecting it because you're giving patients treatment. So what you can't do is collect the data and then decide that maybe your partner who runs a holiday company should be authorised to send them all a mailing offering them a nice recuperation holiday following the treatment. So that would be a breach, a data breach, be it a minor one, but nevertheless it would be a data breach. So that wouldn't be in the spirit of explicit and legitimate purposes. Data needs to be adequate and relevant and limited to what is necessary. So what does that gobbledygook mean? Well, it's got to be necessary for you to provide the treatment that the patient needs and relevant. You know, you don't need to be collecting that the patient has 2 dogs and drinks at the local pub on a Friday evening. So it needs to be limited to what's necessary, and it needs to be kept accurate. So we have a duty under GDPR to keep things accurate and where necessary kept up to date. Very simple for you to do, maybe every 6 months if you've got a patient on a regular basis, or you see a patient whenever you see a patient. Just get them to update records, have a system in place to be able to do that. Now, here's an interesting one for you under GDPR. Data kept for no longer than is necessary. And everybody says, well, what period's that? And nobody can actually define that fully. So for contractual reasons, it's normally 6 years. So as osteopaths, I would, the advice to you guys is 7 years, because you may have financial years overlapping. But of course, in the case of children's data, you'd probably want to retain that to at least the child is 25, because unfortunately, under the Children's Act, laws can be rewritten for children when they reach the majority age, which creates a nightmare for the people who sent me an email in advance of this seminar asking, could I give them a very straight, narrow set of rules and regulations. The difficulty is GDPR doesn't override other legislation. It sits in some cases alongside. In certain cases, other laws may take precedent, but in most cases not. So you will need to keep the data for 7 years or 25 years in the case of until the child reaches 25 in the case of a minor. Data needs to be processed in a manner that ensures appropriate security, so we don't want any data breaches or anything going adrift. So you need to make sure that you've got settings that people can't read your computer when you go off to provide some treatment. And you've also got this new requirement of demonstrating accountability, and I'll talk to you about how you can do that a little later on. So there's got to be a lawful reason for your processing. For all of you, that is not, I don't think, an issue. Just for some businesses, not for you. So you need, data subject needs to give consent. So this is where the documentation comes in, and they just sign the documentation to say they consent to treatment or whatever, but there's a separate piece under there which will talk about the GDPR, and it will say you commit and sign to allow you to store the data, etc., etc. So you get a signature, and that's consent in effect. For marketing, so if somebody phones up your practice and said, send me some information, we all have people like that who we regularly send information to, but for various reasons they never actually contract with us. That comes under legitimate interest. So anybody who's contacting you, ask for information, they can go on your list of newsletters, and you can send them information out, and they can place an inquiry on the website, for example. That's classified as a legitimate interest, and that's recognised under GDPR. Processing is necessary to comply with the legal obligations of the controller. Hopefully you won't have many of these, but there are sometimes legal obligations we have. Somebody's suing us, so we have to process some data to be able to meet those obligations, and maybe other reasons you may be compelled by a court order. Processing is necessary to protect the vital interests of the data subject. This gets, again, slightly into back into the medical field. There may be times when that has to be done. I can't imagine for most of your practices that will be necessary, but in certain cases that can be the case. So a hospital, for example, can say there's a danger that everybody's going to get contagious illness in this area unless they're inoculated, and they can overrule the data subject's rights. Or processing is necessary for the public interest or exercise of authority vested in the controller. So you tend to find that governments use this as a catch-all clause. Conditions for consent. So you, the controller, i.e. your practice, need to be able to demonstrate consent. And for medical records, explicit consent. What do we mean by explicit consent? I don't want you to get too worried about this, but when we talk about explicit, the data subject simply says, I consent to you doing this. So it's not implied, it's consent, and it's explicit. It's explicit because we can read it, and it says, I have consented to you giving this treatment. I have consented to you storing my data under the General Data Protection Regulation. That's explicit consent, very straightforward. Just needs documenting and recording. Documenting and recording is interesting. That could be you handwriting it, could be the patient preferably signing it. I'd like to see a signature on it, or they filled a form in on your website and ticked a box and your computer's recorded that. That's perfectly acceptable, providing it's not a pre-ticked box. Now, we've also got the situation where consent to process data is not necessary for the performance of a contract. So what on earth does that mean? So if you've got contractual obligations, you don't necessarily need consent. However, because you are handling medical data, you do need consent, and you need consent that's absolutely black and white. Now, people can withdraw consent. Can withdraw consent for medical treatment, which I'm sure you're very familiar with, but they can also withdraw consent from the General Data Protection Regulation and say, I don't want you to store my data anymore, I don't want any more records building up. You will still need to keep a minimum amount of data that you need to meet your legal obligations and not to keep contacting them, but people have got the right to withdraw it. We're not entirely sure how this is going to play out. It's aimed at the bigger companies where you can't get somebody like Facebook or Twitter off your case. How this will work out with smaller businesses, nobody understands. So I think we've got consent. I've done a little box at the bottom there, and this presentation will be available to you at the end. But consent of the data subject means freely given, specifically informed, and an unambiguous indication of the data subject's wishes by which he or she, by a clear statement or an action, that's the tick box, signifies agreement to the processing of their personal data. This should not be confused with medical consent, which is separate. All I'm concerned with today is ensuring that you're on the straight and narrow with the General Data Protection Regulation. So there are other patients' consents you need, that's fine, that needs to form a separate part of your documentation, or a separate box. So you just need to be able to demonstrate, I think I've labelled this enough, but if challenged, that you've got consent and how it was given. You've got time to practice to get this in place, so we don't have to rush this all out. So you might find one way works, one way doesn't. Doesn't matter as long as you're where you need to be by May the 25th. Children. Now this is a slight nightmare for you. So children have rights. Unfortunately, children's rights are stacked very much in their favour since the Children's Act. So first of all, children over 16 can give consent. And you just need to use language on documentation that a 16-year-old can understand. And having had two 16-year-olds in the past, even that's a mystery to me. We need also, if children are under 16, then the children, then we're relying on parental authorisation. Now, bear in mind this is for GDPR, not for the medical side of things, but it's for the storage of their records. Now you need to, you think the child is under 16, and the child's giving you instructions, you just need to try and reasonably verify their age. So that's kind of youth card that's recognised. You may just actually get the parents to confirm it. And if you think that's a problem for you, I don't feel it's a big deal, because I don't think you'll have that many children to treat who are not coming in with parents, but are 16 to 18. If you think it's hard for you, the information sites like Google and eBay, which has to abide by these rules, are going to have a complete nightmare. So a lot of their customers fit into this age group. Now, somebody asked me, I think it was Kate, about special categories of personal data. So the GDPR recognises special categories of data. You need to be absolutely clear on this, and this is why you need explicit consent. So effectively, you cannot store information on people's race, ethnic, political opinions even, philosophical beliefs, religion, trade union membership, genetic or biometric data, or health data, information concerning a natural person's sex life or sex orientation, unless you have their explicit consent. So how does this work? Well, in essence, there will still be need for this kind of data in sort of post-GDPR Europe. Otherwise, nobody could join a dating club. Nobody could get medical treatment. So what needs to happen is you need explicit consent, and we've labelled explicit consent already. So explicit consent is it's documented on your paperwork, or you've had an email and you have consent. Where it says explicit, it's black and white consent that you can process their health data. So people have got remedies, and there are liabilities and penalties. So in the United Kingdom, it's the duty of the Information Commissioner's Office, which here have to be abbreviated as the ICO, to take up any patient complaints or potential patient complaints, or potential patients, I should say, who raise complaints. So what would normally happen is they would say to the complainant, please write to the practice with your complaint, and you will be given 30 days to respond. If after 30 days you don't respond, then the individual has got the right to complain to the Information Commissioner's Office for the ICO to take that case up. There are strict timeframes for responding, and if the ICO doesn't comply, the European Data Protection Board can actually hold the ICO to account. So it's a very much compliant framework. Hopefully you won't get any complaints, but we will provide you with some guidance and some best practice in terms of documentation and also verifying who you're talking to. Now, again, this gets all a bit crazy, but I'm just going to cover it off with you so somebody's covered it with you. So the first thing you need to be aware of is people have got the right to a judicial remedy. So if they're not happy with the supervisory authority, the ICO, they can actually take it to the High Court. How many people are going to actually do that, we're not sure. Right to a judicial remedy where the supervisory authority doesn't progress your complaint fast enough. And of course, the ultimate thing is people can take action in the High Court if the ICO doesn't deal with your complaint properly. We don't think this is going to be a big deal for most businesses or smaller businesses, but for big organisations like Google, which has already been to the European Court of Justice due to publishing things that it shouldn't have done, this is going to be an absolute nightmare. So in terms of the right to compensation, people have the right to, if there's been a data breach, either a material data breach or non-material breach. So suffering material breach, you've lost all the data concerning them. Non-material breach, somebody's had unauthorised access potentially to your file. The individuals have got the right to compensation, but that will have to be proportionate. In the United Kingdom, the ICO has actually been pretty fair in terms of the fines it's levied under the Data Protection Act, and we don't think the General Data Protection Regulation will be too different for small businesses, although for big businesses, as I will demonstrate in a few minutes, it will be very, very tough. So, as we've touched on, the controller is liable for damage caused by the processor, and the processor is only liable. Here's the interesting thing. So if there's anybody out there self-employed and you're working in a practice, you're only liable for the wrongful processing. So if the owner of the data, i.e. the practice or the controller, has asked you to carry out some work and you've carried it out on a patient to the instructions given, and it's not worked out for the patient, but you've carried out to the letter what you've been asked to do, you will not be liable. There's also a compensation clawback, which is always a nasty thing, and it basically means if they can't get it from the controller, potentially they could get it from the processor, but they can only get it from the processor where the processor has been negligible. But you could find a processor that went out of business, liquidated, in which case people would then pursue the controller. So it's very important that you document your relationships between you and any third-party suppliers, i.e. self-employed osteopaths. Ensure you've got some insurance in place. And you can actually buy insurance, cyber insurance as well, to protect yourselves if you're worried about risks to your data. And you can actually buy that from companies like Hiscox. I'm sure, you know, a few £100 a year would be delighted to talk to you. You should have registered your practice with the Information Commissioner's Office, the ICO. This is mandatory whether you're just running with paper records or paper and electronic records. If you haven't, just get on and register. Cost is about £36. So, general conditions, these are the fines. And again, I don't want to frighten you. I don't think that hopefully be anybody I'm talking to today will get into any of these kind of levels of fines, but this is extreme examples of what could happen. So 10 million euros or 2% of worldwide undertakings, whichever is the greatest. So not getting children's consent, processing and not identifying who's doing the processing, not protecting data, not cooperating with the supervisory authority. The ICO does get awfully upset if they get a complaint and then you refuse to talk to them. And one complaint's fine, and you might get a rap on the knuckles. You suddenly get 1,000 complaints or 10,000 complaints, and it becomes very, very serious. And I'll show you some examples under the current data protection legislation where the ICO is fined in a few minutes. So, not appointing a data protection officer where one's needed, not providing data security, not having the correct certifications in place. So these will all be part of your checklist, but these are examples that would be certainly hit against very big companies like TalkTalk or Rolls-Royce, something like that, but not necessarily with a smaller, hopefully smaller business. This is the extreme examples. So transferring data outside Europe without the correct documentation in place, not following instructions, disobeying the supervisory authority when they're told you to do something, not having lawfulness of processing or conditions for consent. So, what do you need to do? Well, first of all, we've got to be in a position where you're transparent in terms of how you communicate. So this will all be part of the data privacy notice. And you will put this any privacy notice and you put it on your website, you'll have it as a form, and you may make reference to it in your terms and conditions. However, the privacy notice cannot be part of the T's and C's, it has to be a separate document. We have to use clear language because we have to communicate with anybody above the age of 16. We have to facilitate a data subject's rights of access. So it used to be 40 days under the Data Protection Act. That's now been reduced to 30 days. And you used to be able to charge a realistic fee, ranging from, obviously, fees charged from about £20 up to £50 on the basis it was complex. Fees were abolished under GDPR for the first request, but not vexatious requests thereafter. There's also the need to introduce some kind of ID, so you can't, if somebody's spouse comes on and wants access to medical records, you cannot do that. You have to go through a form of ID or request, and that they have authority. And if you're dealing with a remote patient who's no longer in your practice and can't call in to see this stuff, you've got to go through an application process, do an ID, the usual thing, a domestic bill, and something like a photo ID, like a driving license or passport. So we've got this covers this off here, which is, you've now got in the slide. So information access to personal data. So you ID who it is. The ID, the contact. Yeah, you also need to make available within We also need to make available within our privacy notice this information in terms of how people get access to storing data overseas and what the legitimate interests of our business are. Quite frankly, a sentence on each of these, knock them off, is simply a compliance thing, but if you don't know where to put the sentences in, you could be banging your head against a brick wall, so this will all be done for you. We also need to tell, in terms of that privacy notice, the period we're going to keep the data for, we know that already, the rights to rectification, how they can get data portability, how they can withdraw consent, who the supervisory authority is, and the data subject's failure to provide data, i.e. can treat them as a patient. And this, as it says there, will all be in the privacy notice that we're drafting for you. Right, when obtaining data other than from the data subject, the controller shall provide the data with the following information. So this is, for example, you could be getting this information from a third party, and you may have bought a mailing list. I can't imagine that you would buy a mailing list for the kind of business that you're in, but if you bought a mailing list, you need to tell people in terms of the privacy notice. If you send out a mailing, then you need to tell them about your privacy notice, and this stuff would be listed in there. Information access to personal data. So again, this is Article 15. I'm getting into quite a bit of detail, so I'm just going to skip on. This is just a repeat pretty much of the earlier slide. This will all be within there, but this is rights of access by the data subject. Right, so how's this going to impact on you guys? Well, I don't think it's going to have a major impact. You certainly need to put procedures in place concerning third-party access if you haven't already, and you must be absolutely clear that nothing must be discussed or issued without the written permission of the patient. For remote, as it suggests there, for remote patient access requests, formal ID procedures will be needed, and we will provide you with a suitable ID document, you'll be pleased to know. Now, security. As a practice, we do need you to keep data secure. We've touched on this already. Some of the systems that you're using that I've seen use encryption, and it means the computer's encrypted. There's a program, forgive me, I can't remember the name of the program, but the program out there that does this stuff is designed for osteopaths, and it's got encryption built in. I love that because encryption at the moment is the holy grail in terms of data protection, and it means that you do not need to report this stuff to the ICO if you have a data breach. Pseudonymization basically anonymizes the stuff. It's not anonymization, but it just strips out. And the idea is, for example, in the insurance industry, you might just leave the policy number in there, so you can't actually identify the data subject. However, it's fraught with difficulty because if you lived in the Outer Hebrides, there might not be many neighbours. You could actually identify who the person was just by an address, for example. So that's still a work in progress. Anonymising data would be done perhaps by a university or somewhere else, but it's not desperately useful for treating patients if you don't know who you're treating. So encryption is available. It's available for servers. So if you're running a server at a reasonably big establishment, patient part of your server can be encrypted. I'd recommend that. And then your PCs would be chipped when they try to gain access to that part of the server. General obligations, we just need to have in place a legal contract to ensure that the processor follows through all the things that you do. This is a document I'm going to produce for you. So again, this is dealt with. If your processor finds out new access deletions or returns, well, that basically means if your patient's moved address, your processor actually tells you that information if they find it out. So you might say, well, what's that got to do with me? Well, the payroll company posts everybody's pay slips out, and the pay slip bounces back to the payroll company, who's the processor, because the person it's been sent to doesn't live at that address. Right, now this is what you need to understand in the concept of all of this, which is personal data breaches. So these are companies that have recently had personal data breaches in the last couple of years. So if you were one of the unfortunate customers of TalkTalk, which I was at home, hackers got in there and stole 28,000 credit and debit cards. They didn't get mine, but they also got bank account details. They also stole dates of birth. This was the biggest fine ever issued by the Information Commissioner's Office of 400,000. But it was a major data breach, in fairness, and the hackers were in there for some time, and Talk didn't realise, which is the reason the fine was as high. Under GDPR, they would be fined £55 million. So you can see why people are getting twitchy about this stuff. The money shop in Ireland, or Northern Ireland, was moving a server around. They decided to unplug the server, leave it by the door, and go home to continue moving it the next day, and the server was stolen. People's credit card details, loans had given, and other confidential information was stolen, and they were fined 180,000. But under GDPR, 5 million. Many of you, like me, will probably get emails from moneysupermarket.com. They were fined 80,000, and all they'd done was to send out terms and conditions to people, and they were trying to be compliant under GDPR. However, here's the rub: the people had already opted out. The people had already said, we don't wish to hear from you, but they still mail them with terms and conditions. So if people make it clear to you within your practice, and this is the biggest risk for his practice, if your patients say, we don't want to hear from you again, then take them off the database. If you mail patients and you think they fit under legitimate interest, or you can demonstrate legitimate interest, they're interested in your services that you're offering, you don't necessarily need to revalidate that list. But if you go off and try to revalidate the list and people have already opted out from communications from you, you do risk a fine. And one of the motor companies got into this mess. Flybe got into this mess recently. And Pizza Hut, just looking at Pizza Hut, they've had a load of CVV card details stolen, back of credit and debit cards. So demonstrating compliance, pleased to know we're nearly there, and then we'll move into questions. So establish and maintain a data inventory on the checklist we're going to be preparing for you. Audit your internal controls and processes. Is your data safe? And and I don't mean to be ageist, and I'm knocking on a little bit now, but if you're running a practice and you're knocking on a little bit, get some younger people to look at data security and get their views on it, even if they're not involved in the practice. Because what you might think is a good way of securing data is not. For example, if anybody believes that they can protect a document in Excel or Word with a password, think again. You can buy that password on the internet and it will crack it in 3 minutes. Audit your internal controls and processes, look at your business, review the privacy risks of your patients. Do you leave things lying about? Patient records with other patients' names on. Introduce new documentation such as data subject access request forms we're going to be doing for you. Look at your suppliers. Are your suppliers a liability? Most suppliers will not look after your data in the way that you look after your data because they don't see the sensitivities of it. Create a folder. I'm hoping most of you are running electronic systems. If you've got a server or at least a computer, create a GDPR compliance folder, put everything in there. One of the key things you need to do is to demonstrate that you're trying to be compliant. Because if you do have a data breach, heavens forbid, and the ICO make contact with you, at least then you can show that you're doing things about GDPR. Keep a GDPR audit checklist, that checklist that I'm going to produce for you need to be checking off. Do something and schedule stuff, be realistic, try and do something each week. It's best to do it all over a process of time than rush it and then find you've missed part of the process. You do have, well, May the 25th, 2018 to be compliant, so you still have time on your side.